Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a case law on the transfer of malice, section 301 of the Indian Penal Code. You can call it as doctrine of transfer of malice or doctrine of transmigration of motive, for which mens rea should be present. Such matter has come before the Honorable Supreme Court of India. Justice Abhay S. Voka and Pankaj Mittal, while allowing the appeal of Nanhe, Nanhe, Nanhe versus the state of Uttar Pradesh. It happened in Badam. Nanhe versus state of UP in criminal appeal number 2921 by 2023 on 21st November 2023 held that when your intention is to kill a person and if it fires and another person is killed with the same your thing, definitely you are liable for 301 of the IPC as per the doctrine of transfer of malice. So the heading is like this. I will tell you. Person guilty of murder, he will be held guilty of murder even when he mistakenly kills another person. Supreme Court applied the doctrine of transfer of malice. If you go back to the incident, this incident occurred in 35/2007 in Badam area of Uttar Pradesh. On that day, around 3:30 p.m., the complainant, that is Muhammad Ali, along with his son Saddam Hussein, the son's name is Saddam Hussein, both of them went to a sundry shop or small retail shop to get some articles to their home. They were actually on their way to home. They stopped near that particular shop. But what is happening is the brother of that particular person by name Mahendra and Nanhe, here he is the appellant. Both of them were quarreling with each other. Nanhe and this so-called Mahendra was totally inebriated, in a drunken stage, and he is having a weapon. And actually, as elder, the shop owner asked him to go away from this place. He also advised Nanhe to go. Why are you? Your friends, why are you discussing? Get out. And as a brother, he heard the words of his brother. This Mahendra went to a distance around 20 or 25 feet, suddenly came back and fired at Nanhe. So he wanted to kill Nanhe, he fired at Nanhe. But the result is the innocent boy, Saddam Hussein, who is the son of this Muhammad Ali, he was killed on the spot. And the so-called Nanhe also received injuries. Right? Now a case has been registered. Now the point is, the charge sheet was filed by the police under 304 part 2. Or the charge sheet is filed under culpable homicide against the accused person. And the trial court altered it into 302, basing on section 301 of the Indian Penal Code, transfer of malice. They gave life conviction. The trial court gave life conviction to Nanhe. And actually 2 cases were registered. One is 169 by 2007 under section 304, 308, that is attempt to commit culpable homicide. All these sections were added. 170 is relating to section 25 of the Arms Act. Okay, right, in both cases he was convicted. First case life, second case I think 2 years or so. He went an appeal to the High Court, Uttar Pradesh, but there also appeal was not allowed. Now he has come before the Honorable Supreme Court of India, basing on the question of law, stating that the intention of the accused, the intention of the appellant was not to kill the deceased, which misfired, and as a result of which he died. Maximum it will be only culpable homicide, but the trial court held it under 302. Supreme Court also placed reliance on so many cases. Friends, I remember in the class I told you the case of Emperor versus Musinuru Satyanarayana 1912. Or as per that Pratima, she has shown that Bear Act IPC. In that case, it was written as Public Prosecutor versus Musinuru Satyanarayana 1942. Of course, both of them are one and the same. In this case also, it is clearly held that prior to 1912, what happened? This Satyanarayana, he wanted to kill Appala Narasimhulu, whom he reared for the sake of getting the insurance amount. He has given a sweet meat to him. The sweet was not released by the so-called Appala Narasimhulu. He has thrown away, and a gullible girl by name Rajalakshmi, I think, she consumed the same and she died. So at that time also, the transfer of malice was applied and Satyanarayana was convicted. And in another famous case law, Raj Narayan, Raj Bahrain or something. Yes, that is also very famous case law. And the Supreme Court placed reliance on another case, that is Shankarlal Kachara Bhai. Shankarlal Kachara Bhai versus State of Gujarat 1965. So, wherein, actually, of course, directly section 301 directly say like this, you can get inference that the transfer of malice is equal to the so-called 302. Another case, this is Rajbir Singh versus State of UP. This is also a very famous case. Rajbir Singh versus State of UP 2006. So, here the approach of the High Court in setting aside the conviction basing on the so-called corporeal side is not correct, because transfer of malice. The main point is there should be mens rea, 100% mens rea to kill the concerned person, but it misfired and another person was killed. So definitely the transfer of motive, transmigration of motive will also apply. So basing on this case law, Supreme Court upheld the conviction of the trial court. So no relief could be got by the so-called appellant Mr. Nanhe. So very good case law. Please read it and enrich your legal knowledge. Thank you.